Welcome everyone to our webinar on sweat equity and the ways that it can help your startup to grow. My name is Michaela and I'm joined by my colleague Sarah today. Before we begin, there are a couple of quick housekeeping items that we will go through. So you'll see it on your screen at the moment. The first being that you will receive a recording and the slides in your email after the webinar. You can submit questions throughout the webinar in the Q&A box and we'll answer them at the end. We do also have some pre-submitted questions that we will also answer at the end as well. There will also be a survey after the webinar, so if you complete that feedback, that would be great. For the next 48 hours, you are also eligible to claim a free consultation with LegalVision to discuss how we can help your business. So with the survey at the end that I just mentioned, if you do provide your contact details in that survey, you can claim that free consultation. Now, today, what we will be discussing, there's a few things on the agenda. The first being just generally what is sweat equity. The second being what the types of sweat equity are. So we will go through options versus shares in particular, what the key rights and restrictions attached to sweat equity are. There are some key tax considerations to also keep in mind. Then we'll go through some types of option plans, then another alternative, which is growth shares. And then we'll briefly discuss approvals required in order to actually grant sweat equity. So the first thing that we will go through is what actually is sweat equity, because it is a term that is commonly thrown around, particularly in the startup world. Sometimes you will actually hear it referred to as having skin in the game as opposed to sweat equity, but generally it is referred to as sweat equity. In short, what it essentially means is someone is working for the business, so they're sweating in exchange for equity in the company. So instead of the traditional form of paying an employee above minimum wage or paying your contractors for services, you actually offer equity in exchange for those services that they're giving to the company. Now, one thing just to clarify there with employees, it doesn't mean you get around your minimum wage requirements. There are still those requirements at law, but it is a way to incentivize them above those minimum wage requirements that you might not otherwise have been able to do so. So with early stage companies, it is very effective if the company does have limited funds or capital. So instead of having to outlay expenses that the company doesn't actually have, it can top up that cash salary payment with equity instead. So other competitors in the market might be able to offer more, but in that sense, you can actually bridge that gap where you might not have otherwise been able to incentivize someone, that employee or contractor in that circumstance. Now, regardless of if the company does have the funds to be able to pay an employee or contractor a higher salary, it can also be an alternative way to just incentivize employees generally anyway. So it is a good avenue to think about just for incentivizing employees or contractors. The main reason being that if someone has a stake in the business, they're more willing and probably more likely to go above and beyond in order to grow the business and make sure that the business becomes profitable. So it does align their interests more with shareholders of the company who obviously are thinking about the growth and the profitability, as opposed to just someone who is coming in day to day and working for the company and not really thinking about the actual growth opportunities. So having an ownership stake will mainly mean that they want to work and that extra mile in order to make sure they're also benefiting from the growth of the company. Now, whilst some of you watching might be aware of generally what sweat equity is, there are, I guess, details and requirements which aren't as commonly known. And also a lot of people aren't aware of the various types of sweat equity that you can offer. So there are various options available to companies. It's not just one option that you can go with. So before you get started down the road of even thinking about sweat equity, it's important to understand, one, the legal requirements of how you can actually go about offering that to employees or contractors, but also what structure might be best for the company in its particular circumstances. So I'll hand over to Sarah, who will firstly just go through some of the types of sweat equity you could think about.
Yeah, thanks, Michaela. So sweat equity normally comes in two different forms. So it tends to be options or shares. So shares, I'm sure you've all heard the term shares. So really it's just a unit of ownership in a company. So for example, if there was a company that had 100 shares and you own 25, then you would have a 25% stake of the business. Conversely, options are just a right to purchase shares at a future time, and you can attach certain sort of conditions or requirements on their right to convert into shares, but effectively it's a future right. So right now you have an option, once it's exercised, you would have a share. One misconception actually is that you are granted options over a certain fixed percentage of the company. So let's say you gave an employee 5%, they would always hold 5%. So that's not actually the case. Instead, what should happen is you can work out the number of options, so the right to get shares that you're happy to give your employee. Right now, that might represent 5%, but that won't necessarily be the case when they go on to exercise their options and get shares. For example, if you've done a capital raise since then, or maybe if you've issued other shares to employees, then let's say, for example, you started off with 100 shares, you gave them 5, so right now they have 5%. By the time they go to exercise those options, you might have 200 shares in issue. So their 5 shares no longer represents 5%. In that case, it would be 2.5 instead. So actually, you're not fixing the number up front in terms of the percentage. You are just saying this is the number of options you have. What that actually then ends up meaning, you don't necessarily know until they actually exercise. So I think employees often say, great, you've given me 5 options. What does that actually mean? It's difficult to say because obviously you need to take into account what the value of the company is and also what percentage that's going to end up representing, which right now you don't know. So that's just kind of a conversation piece to have with your employee. That's obviously specific to options, but a similar thing does happen with shares, because even if you gave someone 5% of your shares now, if you did go on to issue more, so again, let's say, for example, a capital raise, then that person would get diluted down. They wouldn't always hold that 5%. So it is a similar concept with both, but sort of just thinking from your perspective, not promising anyone that they're definitely going to get a certain percentage of your company on an exit is a better way to do it. You're just promising them a certain number of shares or options now. When you're deciding how many options or shares to give to an employee, it's still helpful to think about it as a percentage. So, what you're comfortable to give away now, and then work out what that number is. And one thing to flag is that you need to make sure you can actually issue that number. So we see a lot of clients where they've set up companies with kind of 1 share or 10 shares. You can't then give someone a small percentage if you've only got 1 share to play with. So we often end up doing share splits for clients. So actually they then have sufficient number of shares that they're holding, so you can give a smaller percentage of options or shares to your employees. So another difference between options and shares is that option holders don't attend and vote at shareholder meetings, and they don't participate in any dividends. So they don't actually have shareholder rights until you've exercised the option and turned it into a share. Obviously, shareholders have those rights from day one. So really the first question when you're considering sweat equity is, are you going to be offering shares or are you going to offer options? And we'll go into different types of option schemes and a type of growth share later on in the presentation to give you a bit more detail on this. So other key questions to consider is the actual amount of equity that you're willing to give. So as I said before, it's helpful to think of this like a percentage, being aware that that will change over time. But in terms of a percentage, what are you happy to give away? Factoring in all the different employees you might be wanting to incentivize and your future plans, for example, capital raising. Also, what parameters you want to set around about when the employee can actually get value out of that sweat equity, and also any terms attaching to it. So I'm thinking about things like vesting periods. You probably have heard of vesting. So this can apply to options, so they can't actually exercise options until they vested. That could be based on a time frame that worked for the company, or it can be based on a milestone. But you can also get this to apply to shares as well. So effectively, the employee has to earn the equity for it to actually have a value. and also when the option can be exercised. So, does the employee have to wait until you're selling the company? Do they just have to wait until the option's vested and then they can get a share? So there can be different things that you can do within your option plan as well. And then lastly, as always, there are tax considerations for these things. We will go into it in more detail later on, but there are some tax efficient schemes which exist for options, for example, an EMI scheme, which Michaela will be talking about later on. Sorry, I've just lost the slides. Just getting them back. Oh, there we go. So really, these questions are commercial decisions. So it's going to come down to really, who are you incentivizing? For example, how key are they to your business? Is it appropriate for them to have shareholder rights? Or is it really only appropriate for them to hold options now and just get a share in an exit proceeds? So really, it's just kind of a monetary reason why you're incentivizing them. You should also be mindful of current shareholders and what they would be happy for you to give to your employees without actually you getting any cash in return for that. So, for example, if you have future capital raising plans, you want to make sure that you're not getting diluted below a certain point as well. So just taking into account, if you're giving away 10% of your share capital to employees, what does that then leave everyone else with? So just making sure you've sort of thought about other shareholders and your future plans as well. Great. So I'll hand back to you, Michaela, to talk about the key rights and restrictions that you can attach to sweat equity.
Perfect. Just before I get into that, there was one question that just came through of how long will the conference last? So it's until 11:45. So just for that answer. But otherwise, I'll go through now just some of the restrictions and key rights which do attach to sweat equity. The first one that I did want to talk about is vesting. So Sarah briefly mentioned it before. You might have heard of vesting in the sense of sometimes you hear of reverse vesting, for instance, with shares in the company. Essentially, what vesting means is that there's certain requirements that need to be met until that person takes full ownership of that option or share. Now, in the case of shares, obviously they get the shares up front, but in order for them to later be able to sell their options or be fully entitled to them, the vesting requirements need to be met. Options are slightly different. So if an option is offered, that person generally wouldn't be able to exercise, subject to other restrictions, but wouldn't be able to exercise their option to convert it into shares until the vesting requirements have been met. So vesting can be a very important part of sweat equity. The main one that you tend to see is what we call time-based vesting. So it's just purely related to time. And you'll often hear the term thrown around of, as you can see on the screen, 4-year vesting term with a 1-year cliff, or 4-year vesting term with a 12-month cliff. What that essentially means is that individual who has been offered options or shares, those securities will vest over a 4-year period. So I'll use the example of options here just because it's a little bit more simpler. But after 12 months, that individual will receive 25% of the overall options. And generally, they can then convert those options into shares for that 25%. And then over the next 3 years beyond that, the options will vest more frequently. And generally, what you see is that every quarter, another portion of the options will vest. So in that scenario of a 4-year vesting period, if that person, say, leaves employment within 2 years, they are entitled to 50% of the options, but the other 50% in that case would, what we say, lapse. So they wouldn't be entitled to them. I'll go through leaver scenarios in a minute as well. But before I do, there are other instances of vesting requirements. So instead of time-based vesting, you can also use what we call milestone or KPI-based vesting. It's not as frequently used as time-based just because it's a little bit more complex. Obviously, it's very easy to prove whether a time has been met. So it's just a 12-month period. It's very easy to show that vesting requirement has or hasn't been met. But with KPIs or milestones, it really needs to be clear and easy to measure if you're wanting to go down that route. So, for instance, if you said that the milestone was the employee has done a really great job this month, that's going to be very difficult to prove, as opposed to saying, in order for them to get the first 12 months of their options, and in order for them to vest in that 12 months, the company needs to earn X profit in the first 12 months. That's easy to show whether the milestone has been met or not. But in saying that the employee has worked great this month, if there is, I guess, a dispute over whether that was the case, it's going to create a form of conflict, because you can't easily prove that that is the case. So when you're using KPIs or milestones, it's very important to make sure that you're getting that reviewed from a legal perspective, because you want to make sure there's no potential disputes down the track for that. And I briefly mentioned it before, but there are also restrictions around when someone leaves the company. So with that example of the 4-year vesting period, if someone did leave within 2 years, there's 2 general scenarios that you will see, and they're what we call good leaver and bad leaver. So in the case of good leaver, so this is if someone is just leaving in good circumstances, they've found a new job, and it's just time for them to move on. Generally, what you will see, and what is market standard, is that in the instance of options, the company might let them keep those 50% of options that have vested, but the remaining 50% that they're no longer employed in the company for that time period would just automatically lapse. In the alternative of shares, they've obviously already been granted all of the shares up front, but for those 50% that have vested, again, they might be able to keep those shares, whereas the remaining shares would have to be bought back by the company, and the buyback would depend on what the company has agreed in advance. On the flip side of that is a bad leaver scenario. So this is if someone left in bad circumstances. So if there was misconduct and they've been terminated, generally in that case, you'll see that they don't get market value if the shares are being bought back for what has vested, or for instance, if it is options, and they'll only get nominal value for that. So it's seen as sort of a discount given the circumstances. So there's different ways that you can structure it for bad leaver, good leaver, and it will depend on, I guess, how the company views it and also the particular circumstances of the company. But they're things that you need to be keeping in mind. And you'll see as I went through that there are differences between offering shares or offering options. So generally, if the company has offered options, it's a lot easier to deal with someone who has left, because they're not registered with Companies House. You don't have to do a formal buyback of the shares. Whereas if someone is a shareholder, it becomes a little bit more complex. Similar processes, but there's just more administrative hurdles down that path. So it's very important that you consider whether the company wants to go down the option route or the share route. And now I'll hand over to Sarah, who will go through some of the tax considerations.
Thanks, Michaela. So as Michaela was just saying, you need to make a decision there around options and shares, and tax is going to be one of those key things that helps you make that decision as to what's going to work best in your scenario. So there are a number of tax implications that can arise when you're issuing sweat equity, and it's going to really depend on the type of equity that you are issuing, so options versus shares, and what, if anything, is being paid for that equity. So you need to look at it from both the point of view of the employer, so your perspective, but also from the employee side. Typically what we're talking about here is income tax that needs to be paid by the employee, and that can also trigger national insurance contributions that need to be paid by the company as well. So if you think about a scenario, sort of an investment scenario, you would be issuing shares, and in return you would be getting a cash payment that equals the market value of the shares. So there's no tax issues there. You're giving someone shares worth a certain amount. In return, you're getting the equivalent in cash. Also, the investor probably isn't working for the company, so there wouldn't be any income tax consequences anyway. But with sweat equity, you're giving an employee equity in return for non-cash consideration. So effectively just future services that they're going to perform, and they are working for you. So HMRC can look at this arrangement and say, well, the only reason why this person got shares is because they're providing services, and it was effectively in lieu of giving them additional salary. So we're going to tax the value of those shares as if it was income that that person received. So it's called a dry tax charge, effectively because that employee is going to have to pay income tax in the year they receive the equity, although they haven't actually received any cash proceeds yet. So they're having to sort of pay that income tax out of their own pocket rather than from any proceeds from those shares, which obviously isn't ideal situation for them. So often clients aren't necessarily aware of there being these tax consequences when they're issuing shares. As I said, it also is relevant to the company as well, because they might have to pay national insurance. So what's really key to think about here is what the market value of the equity that's being issued is. So if you're really, really early stage, you might be able to argue, well, the market value of my shares is insignificant. It's really just the same as a nominal value because, for example, we haven't traded yet, or we haven't made a profit, or we're still in sort of design stage. So really, it's not worth anything. So in that case, obviously, you can say the market value is really low. But if you are making a profit, or if you've either completed a capital raise, or maybe you're about to do one, then it's more likely that the market value of your shares isn't going to be the same as a nominal value. There is actually going to be sort of a market value for those shares that somebody would pay that's a bit higher. So the reason why it's important is because if employees do need to pay income tax, it will be on the difference between what they paid for the equity and what the market value was. So obviously here, if you can argue that your market value is really low, then the employee probably could pay that. So let's say you've got penny shares and nominal value penny, and you haven't really done anything yet, you're effectively still pre-revenue. You could say, well, the value of the shares is just a penny. An employee can probably just pay that up themselves, and then they've effectively paid market value, so there's no income tax issues. And there is something called a Section 431 election that we recommend get signed at that point. But yeah, that's probably getting a bit technical, but there are elections basically that the employees can sign at that point just to confirm they have paid market value. Obviously, if your market value is high, then it might not be feasible for someone to do that. One of the real risks is if there were income tax payable in the year that you're issuing the equity, it's not paid. When that employee goes on to sell their equity, HMRC could say, well, this is the percentage that we didn't get from you as income tax, so we're going to apply that same percentage to your sale proceeds and put that subject to income tax instead. So obviously, normally when you're selling an asset, it's just capital gains. That's what you want. It wouldn't be very good if some of your gain was actually income tax, normally a higher rate. So that's really the risk around not having sorted out the income tax consequences to start with. What this means is that quite a lot of startups actually go on to use an option plan, and typically, if they can, an EMI option plan, because it actually has its own kind of tax regime, and you can be really clear that there's no income tax that's going to be paid. And yeah, Michaela will go on to talk to you about this now, so it's a really good thing to be aware of.
Yeah, definitely. So as Sarah said, there are certain types of option plans that the UK government has actually approved. And what they mean is that the employee under these approved plans generally doesn't have to pay income tax when the options are actually granted to them or when they're exercised. So all of those tax benefits that Sarah was just going through. The most tax efficient one that we see, and the one that we usually recommend to our clients, just given the nature of them, is what we call an EMI option plan. So that's an enterprise management incentive. The eligibility criteria, there is an extensive list of criteria to be met, but the criteria needed for an EMI option plan actually means that it's more suitable for early stage companies. And there's a few reasons for that, but the main ones being that one of the criteria is that you need to have less than 250 employees. So obviously that caters more to early stage companies or smaller companies. You also need to make sure that the gross assets of the company hasn't exceeded £30 million. So there are those thresholds that you need to make sure are met in order to be going down the EMI option plan route. There are some other limitations. So one of those being that the company cannot offer more than £3 million worth of options in itself under an EMI option plan. And any one individual employee can only actually be granted up to £250,000 worth of options. Now, you'll notice that I've been referring to employees, not contractors, with an EMI option plan. The reason for that is that only employees are entitled to the EMI tax benefits under an EMI option plan, and contractors don't actually meet the criteria for the eligibility criteria for that. One of the things that you need to keep in mind when you're looking down this route of an EMI option plan is that there are certain timeframes. So one of those being that you actually have to get a valuation approved for the option price by HMRC before you can actually look to offer EMI options. Now, once that valuation is approved by HMRC, you then have 90 days from the date of approval in order to use that valuation and offer options under that valuation. If you exceed that 90 days, you then have to re-get the option price valued by HMRC again. So the reason that you get that valuation is that when the employee pays the exercise price, when they're actually exercising those options into shares, they won't have to pay income tax when they exercise or sell the options if that option price has been pre-approved by HMRC. All they'll have to pay is the CGT on the sale. But again, if you're using an EMI scheme, it's actually easier for employees to qualify for business asset disposal relief, for instance, so it reduces CGT to 10%. So there's more than just the income tax benefits for employees under that. And with the company, again, as Sarah said before, from a tax perspective, employers won't have to pay the NICs, so the national insurance contributions. So that's something to keep in mind as well. Now, if the company or the employee doesn't qualify for any of the EMI eligibility criteria, there is more than what I've just gone through. That's just a short list of some of them. But for instance, if the company had already offered £3 million worth of options under an EMI plan, they then might look to explore other schemes that can be used. So one of those is what we call a company share option plan. So that's a CSOP. It's an alternative. It has different eligibility criteria. So usually later stage companies would be using a CSOP, but it's similar to an EMI in the way that it works. There's just different criteria that need to be met to make sure other tax benefits can be used. There are other ways to go around options versus shares. So I'll hand over to Sarah now, who will go through growth shares, which is another way to think about.
Yeah, thanks, Michaela. So as you can see, the EMI scheme is great because you have certainty as long as you've got that HMRC approved valuation, and as long as that's what the employee is paying when they exercise the option, you know there's no income tax consequences that were unintended. So it's obviously really good from that perspective, but it is a bit more hard work upfront because you have to put together an actual option scheme, and you do need to get that HMRC approved valuation. And as Michaela said, it only lasts for 90 days. So you might be in a scenario where perhaps you're issuing equity to your employees or contractors quite often. Well, contractors don't qualify for EMI in particular, but let's just say employees then for the sake of argument. If you are issuing options to employees, you know, multiple times a year, you might not really want to have to keep going to HMRC and getting the valuation done. Often we recommend clients sort of use a professional valuer for this, so it can end up being a bit expensive if you're having to do it multiple times. So it might not actually be the best option for you. Or you might just not qualify. You know, you might be a larger company that doesn't qualify anymore. So you might consider granting shares to your employees instead, rather than using an option scheme. Equally, if you're really early stage, like I said before, so you can justify that you have a really low market value that's effectively equivalent just to your nominal value, then also the income tax issues are a lot dampened, because obviously if you don't really have much of a market value, as I said before, you can get the employee to just pay that amount. So you don't really need to be worrying too much around there being a massive income tax bill for them. So again, in that scenario, you might decide, actually putting together an option scheme is quite a lot of upfront work. I don't really need to do that because I have such a low market value. I can just issue shares to my employee straight away and they can actually pay market value, so it's fine. So yeah, there are circumstances where maybe option schemes just don't work for you. In which case, if you're going down the shares route, you might issue just ordinary shares, which is the same class that you would have as the founder, but you might also want to consider creating a new class of share. For example, you could create a share class that doesn't have voting rights. So you are then giving employees the right to participate in dividends and the right to share in the proceeds if the company's sold, but actually in the interim, they don't have any voting rights if that's not really appropriate. So that's something that you can think about. Otherwise, if the reason why you're not using an option scheme is because you are a larger company, you've been trading for a while, your shares do actually have a higher value, then actually you can't go down the route of just having your employees pay the market value up front for the shares, because obviously that's going to be quite a large bill for them. So what you can do is create a new class of share, which often is called growth shares or hurdle shares. So what this means is the rights attaching to these shares are limited, so that the employee will only ever share in any exit proceeds if the valuation is above the threshold that you set. So for growth shares, normally the valuation threshold is your value at the time the shares are issued. And for hurdle shares, it tends to be a future value that you're trying to achieve. So really it's good for kind of senior staff. And if you have been going for a while, and you're hiring someone to help you grow even more, and maybe even to get you to a company exit, it makes sense to incentivize that person to try and get an exit above a certain valuation, because that's the point at which their shares kick in and give them some value. So, for example, if your company has a £10 million valuation, if you created some growth shares, as long as a company's sold for more than 10 million, let's say you gave someone 5%, they would receive 5% of the proceeds above 10 million. If you created hurdle shares, you could set the hurdle, let's say 12 million. So you're giving these shares out when the company's worth 10, and actually they wouldn't share in the proceeds. Let's again say 5%, they'd get 5% of any proceeds above 12 million. So that's really incentivizing that employee to grow that company to achieve that higher valuation for you. So as you can see, the market value of a share, where you're only getting proceeds above 10 million or 12 million in those examples, is going to be much lower than if you can just share in 5% of all the proceeds, and you're basically getting 5% of the 10 mil. So as you're only getting above that threshold, that hurdle, the market value of those shares is much, much lower. So you can then get that paid up by the employee when they are issued those shares and avoid those income tax consequences. So obviously it's difficult to actually know what the value of that share is. So we do recommend that you speak to an accountant and a valuation expert, so they can help you say, okay, this is your market value of a normal share. These shares that have these parameters attached to them, this is the lower market value. So that's just something that we would recommend to make sure you are doing it properly. So that's growth shares. Just the last thing we're going to cover is just approvals that you would need to grant sweat equity in the first place. So as we mentioned before, you do need to consider the rights of your existing shareholders, your articles of association, and if you have one, your shareholders deed is likely to contain a process for going through issuing any new equity to the existing shareholders, which is called preemption rights. It's a really good idea to have these documents reviewed by a lawyer before you start issuing options or shares, because there may actually be some provisions in the Companies Act which apply when issuing shares, which aren't stated in your articles. So you might not know that those exist. So it's really important to make sure that you are getting the correct authorities. So there's sort of two parts of this. One is making sure the directors actually have authority to allot the shares. This is actually a Companies Act restriction, which means that the directors can't just go and issue shares with different rights without getting shareholder approval. And the other one is the preemption right. So sometimes this is called a right of first refusal. So what this means is if you are wanting to issue any new shares, you have to first offer them to your existing shareholders. It's effectively an anti-dilution protection for them. So they have the right to subscribe for those shares to maintain their percentage, but it's a process. So, it could take a number of weeks to go through that as it's set out in your articles. So often you want to ask shareholders, we're going to be issuing shares to this person. Will you waive that preemption right? And typically for things like employee option plans, there can actually be kind of an allocated pool set aside for these options. So I think clients often think that pool exists. It doesn't exist until you've actually issued an option. But what it means is the directors have approval to issue options or shares as long as they don't go above the pre-approved threshold. So let's say 10%. without having to ask shareholders and go through that preemption process. So really, it's just an exception to the preemption rights and just a pre-approval that the directors have. So yeah, they're obviously important to make sure you've got the right things in place, so you're not actually breaching any provisions in your articles when actually issuing the sweat equity. Brilliant. So that concludes the main part of our webinar. So we've had some questions submitted, which we will go through in a moment. But just before I do that, if you do have any questions, type them in the chat box now. We had some pre-submitted, but always good to see if anyone else has any questions. We've got a free download that you can download our UK Startup Manual. You can scan the resources tab, scan the QR code here, or look at it in the resources tab. That's a really helpful manual that we've put together over the last year, just really setting out, if you're starting a business in the UK, what you need to be thinking about. We've also got another webinar that you might be interested in, selling a business, tips for a successful sale. It's on the 5th of November at 11 o'clock. So do register for that if that's of interest. While you're submitting your questions, Michaela will just go through with you how we work with our clients typically, as it's on a slightly different basis to a normal law firm.
Yeah, definitely. So you'll see on screen there that there's some information around becoming a LegalVision member. So basically the membership is a way to get unlimited access to the full team of specialist lawyers for all the business as usual legal needs. So it's kind of like having your own in-house counsel, as you'd say, for a fraction of the cost. So you'll see some of the ways that we can help on your screen, but basically there's unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registrations, but others as well. So to learn about how we can offer a membership or how membership can help you, you can request a free consultation with the survey at the end of the webinar. But now what we'll do is we'll go through some of the questions. So there were a couple of questions submitted around seed capital, avenues to raising capital, how to decide and where to start looking for capital. So this webinar was more focused around sweat equity, which is a little bit different to, well, it is quite different to traditional forms of investment and raising capital. Myself and Sarah, we actually did a previous webinar on startups and raising capital and basically the basics for raising capital. So if you go onto YouTube and you just search that raising capital LegalVision webinar, you will be able to find that, and I'd recommend that as a starting point. Otherwise, I'd also recommend requesting that free consultation because then we can explore how we can assist you with that side of things, but there's just not enough time to go through that now, so apologies for that. Then I think the next question is, what's the most efficient incentive reward system for a startup business? So Sarah, do you want to answer that one?
Yeah, sure. So we've gone through a few options with you today, but on the whole, what's going to work best is really going to depend on your specific circumstances. As I mentioned before, it will depend how early stage you are, what your market value is, if you can issue shares at a low price because you have a low market value. If you can't, does it make sense for you to do something like an EMI scheme if you qualify? Because then actually there's no income tax payable now, but actually employees don't have to pay any exercise price until they're really receiving proceeds if you are letting them exercise on an exit. So that can be really useful. It's also worth thinking about who are you incentivizing, because that's obviously going to be a big difference as to what scheme works better for you. For example, if it's someone that's really key, maybe even like a co-founder, you see clients, and a lot of businesses, a lot of our clients are in the tech space, who they really need a CTO to come on board, and that's a really key person that's almost like a co-founder. Is it appropriate to give them options where they have to wait to get those? Investors can't see they're holding any shares in the company. Maybe not. So for that kind of scenario, you might just want to give them shares up front. Again, the tax consequence on that will depend on what your market value is at the time. But in that scenario, they would then be a shareholder from day one, and they'd have shareholder rights, and that might be appropriate for you. But also don't forget there are other ways that you can incentivize your key workforce, which actually doesn't involve equity, which sometimes can be more appropriate depending on the circumstance. So, you can set up a bonus scheme linked to performance or targets. You can do sort of profit sharing arrangement or referral scheme. So there obviously are lots of things that you can put in someone's employment contract that's not necessarily to do with them getting shares if that is more appropriate. Actually, we got a question just in from someone on the webinar now about, can you mention some pros and cons of hiring employees as opposed to contractors, as much of the sweat equity appears to depend on this? So yeah, this sort of ties in with it. So again, what's going to be appropriate in the circumstance will depend on who this person is. Because yeah, you're right, as you said, if it's an employee, then they can have EMI, but if it's a contractor, they can't. So I think key things to think about here is, who is this person and how much control do you need to have over them, and how much time are they devoting to the business? So if it's someone that really, they're working for you full time, you want to make sure that you can really supervise them. You want to make sure they are the only person that can turn up and do that work. Then an employee role might be more appropriate there, because then you do have kind of more control over your supervision. There are also obviously employment rights that come with that. So you need to just be aware, as soon as someone's an employee, you've got minimum wage you need to be thinking about. They can end up accruing sort of unfair dismissal rights, and we'll have to see when the budget comes out. So if that's changing, there is some murmuring that might be. But at the moment, they need to have a certain number of years of service in order for them to have those unfair dismissal rights. So sort of it is more of an onus on the company if you are actually employing someone. So contractors tend to be more, if you need someone just ad hoc to provide services, then a contractor might be more appropriate. Often you see it quite a lot in the tech space. If you need someone to just help build a bit of your website, and then that might be appropriate for it to be a contractor. If you're happy for them to be able to actually substitute, so for example, if they couldn't actually deliver on a bit of your project, can they give it to someone else who can? Obviously with employees, they're not allowed to do that, but with contractors, they are. So again, it's going to depend on the circumstance, who this person is, what kind of services they're providing and on what basis. But yeah, it's something to think about as well. So you can still give shares to your contractors. You can still give options to contractors. They just won't get that tax relief because they can't qualify for the EMI plan. But also, they do need to be declaring it in their tax return. Obviously, it's not as big a problem for the company because you're not paying their national insurance, and you're not doing paying their income tax at source through PAYE. They are responsible for their own, but doesn't mean they don't have income tax consequences, which again, I think is a misconception. People think, oh, I can just give this contractor shares rather than paying them for their services, and that's that. Actually, that contractor probably does have income tax that they might need to be declaring for the value of those shares that they received. We probably have time for maybe one more question. So Michaela, do you want to take the next one, which is considering the negative outcomes of the initiative, but also if everything goes gloriously, what terms would you include at the beginning to prevent future disputes? For example, if the company grows exponentially in the first year, what should have been in place from the beginning so both parties are happy?
Definitely. So this is probably a good one to actually finish on. I can see we only have a minute left, so I won't be able to go into too much detail with the question, but basically from the outset, it's a good idea to be getting legal advice on what options are available for your company. In particular, each company is different, each circumstance is different. So it's important to get that legal advice from the outset. You need to make sure all of your documents are prepared correctly, particularly if you're looking for a tax beneficial scheme, because there are a lot of requirements to be met. And for instance, the governance documents of the company, so the articles, the shareholders agreement, to avoid any future dispute, you want to make sure that they're prepared properly from the outset. Another consideration to think about is that as a founder, you need to make sure you're comfortable with the amount of equity that you're giving away, as Sarah mentioned. And usually that's in the realm of 10 to 20% if you're looking at employee or contractor options or shares. But yeah, essentially it's making sure that you know what you're going to be offering. You have those legal documents in place and it's all above board. It's all been properly prepared. So that's why we recommend that you get legal advice on that. And that will essentially bring us to the end of the webinar. So you'll see, Sarah, do you mind just going to the last screen on the complimentary consultation? Just one over. There will be, yeah, there will be a survey that will come through to your email after the webinar. So if you complete that survey, you can also include your contact details to receive that complimentary consultation. Unfortunately, we couldn't answer any of the other questions. We have run out of time. We're over now, but we do value your feedback. So if you can give that feedback in the survey, that would be great. And otherwise, yeah, thank you for joining us.
Thanks, everyone.
Thanks.